Officer Dave, would you open my courtroom for me, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Ms. Strickhardt, good morning.
Good morning, Judge. How are you doing today?
Good, how are you?
I'm good.
You have Midland Credit versus Kevin Hurst.
Yes, Judge.
Okay, I have Mr. Hurst. Let's see if we can't get started. Turn on your microphone, Mr. Hurst. All right, we are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhardt, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right, where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking
Yeah.
if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock? Does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan Court Rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other side. July 26th at 10 o'clock, we'll hear the motion. Thank you all for coming in. We are off. Yes, sir.
Have a good one.
And you too.
Thank you, Your Honor.
Who's my- Mr. Neal, good morning.
Good morning, Your Honor. How are you?
Oh, good. How about yourself?
Not too bad.
You have what file? Michigan First Credit?
That's correct, Your Honor. Last three is 013.
Okay, I do not have your opponent as of yet, so I'll put you back in the waiting room.
All right, sounds good. Thank you.
It's Neal. Wait, five. That's going to be Kiefer's phone. Michael Norman.
Good morning. Kiefer Brown.
Mr. Brown, you're kind of sideways there for me.
Oh, sorry. Yeah,
Let's get the other guy in here, okay?
thank you.
Where's Mr. Norman? Where's Mr. Norman? There's Mr. Norman. All right, Norman, we are on the record. This is 2-1-169-485. Kiefer Brown versus Protected Door and Window. Your respective appearances.
Michael Norman appearing on behalf of defendant protector,
You got a member bar number
P75844.
and your name, sir?
Kiefer Brown.
Okay. All right, gentlemen. We have a motion for summary disposition filed on behalf of the defendant in this matter. And we have since that time gotten a statement from the court reporter saying that there is no transcript for the August 13th case. So we're not going to be able, obviously, to have a video record of that. So we'll just, are you guys ready to calendar that motion? You got Mr. Brown's answer, Mr. Norman?
I did. And yeah, we could definitely calendar the motion. I don't know what the court's position is on this, but given that there's no recording of the prior conversation, I don't know if it's better if this is something the court would be willing to set for mediation or case evaluation.
Well, I think as a practical matter, I can tell you, because I pulled the file and I looked at the other record, and the dismissal provides case settled, closing documents to follow. Closing documents never followed. So I really don't know what I would be able to do for anyone on a motion for summary disposition in the absence of those kind of documents. So what I think we should do here is I think the case ought to be set for case evaluation. And at this point, I will simply dismiss the defendant's motion for summary disposition without prejudice.
Thank you, Your Honor.
So what you can do, Mr. Norman, is you can send me an order referring the case to case evaluation. Mr. Brown, case evaluation is how to say this? It's an alternative dispute resolution. And it does two things. There's a 3-lawyer panel, one who represents plaintiffs, one who represents defendants, and one who's neutral. Each party makes a written presentation to that panel. Then you come in, well, I guess you don't come in, but you do a virtual hearing with them, in essence, where each side says, this is what my case is about, and this is what I think the case should be evaluated at. Now, understand that the purpose of case evaluation is not a trial, it is to settle the case. And then what they do is that that panel of lawyers will discuss the case amongst themselves, and then they issue a written evaluation. If that evaluation is unanimous, there's a very important trigger that you need to understand. If the evaluation is unanimous and one side rejects it and the other side accepts it, you reject it at the penalty of being, if you don't do 10% better at trial, having to pay the other side's attorney fees. Let's say for purposes of our discussion the case evaluation was $100. That means at trial, if you don't get a verdict of $110 or more, you will have to pay the attorney fees for the other side that have been incurred since the time of case evaluation. And typically, what happens in that regard is that the lawyer for the other side says, okay, on this day, I did this task at this number of hours, this number minutes, this number and lists those dates and times, and then applies an hourly rate. The hourly rate is based upon the complexity of the case, the nature of the case itself, the experience of the lawyers, and things of that nature. In general, what we look at is we look at the state bar every couple of years publishes a, for want of a better phrase, a sort of a guideline to what typical attorney fees are throughout the state, divided by regions. Obviously, an hourly rate in Detroit is going to be different than the hourly rate in Iron Mountain. So let's say, for purposes of our discussion, in the example we were using, that there was a $100 verdict. Because that $100 verdict is not 10% better than the $100 case evaluation, even though the plaintiff won, the plaintiff would be subject to paying attorney fees. Let's say, for purposes of our discussion, the attorney fee typically is going to be in the neighborhood of $150 to $200 an hour. Let's use $175 as an average. So let's say there were, for purposes of our discussion, 10 hours of time expended after the case evaluation until and including the trial. That's $1,750. So even though the plaintiff had won in that case, the plaintiff would end up owing $1,600. So the purpose of the case evaluation is to settle the case. And the reason that case evaluation typically settles cases is because of the teeth involved in the sanction of having to pay the other side's attorney fees. So what I'm going to do is I'm going to do two things. Well, actually, I'm going to do one thing, and Mr. Norman is going to do the other. I am going to enter an order today dismissing without prejudice the defendant's motion for summary disposition for the reason that we can't find the necessary transcript. Mr. Norman is going to submit an order that I will sign and send a copy to you and to him, submitting the case to case evaluation. Then what will happen is you'll get a notice from the case evaluation. You'll have to pay the case evaluation fee, and then they will give you a date for your hearing. Prior to that time, you will have to submit your case evaluation, your statement, I guess you would call it. And there are 4 statements that will be necessary. One goes to Mr. Norman. 3 copies go to the case evaluation people. So each one of the lawyers has in front of him or her a copy of that statement. So I'll look forward, Mr. Norman, to your order. Typically, Mr. Brown, those things are going to take about 45 days to get a hearing scheduled and heard. So I'll give you guys a return date. The return date will be in mid-August. Now, if we have not had both the case evaluation and the time for you to decide, because you get 2 weeks to decide after the case evaluation, do I want to accept it or do I want to reject it? And then you file a pleading with the case evaluation people. Yes, I accept, and no, I reject. So let's get you guys a return date and get you on your way.
Your Honor, I had a question. With me representing myself, can I charge the same fees as attorneys? Because I had to do my research too and get information. And
you can do whatever you want, but there is no precedent in state of Michigan for a non-lawyer to be awarded attorney fees. So let's give you guys an August 16th return date. That's a Tuesday, gives you about 45 days. Mr. Norman, I look forward to your order. August 16 at 10 o'clock, we will have our next pretrial. And by that time, hopefully you will, if you don't have, because these things I don't control them. If you don't have your evaluation done, you will at least know when it's going to be. So August 16th at 10 o'clock. Now, there's another alternative. The alternative is I put you guys into a chat room and you work out your problem. But in the meantime, what I would suggest, what I'm ordering is Mr. Norman's going to submit that that order for case evaluation. I'm going to send you guys first today a pretrial order for the August 16th date. I'm going to send you guys today an order dismissing without prejudice the motion for summary disposition for the reason we can't obtain the transcript. And then when Mr. Norman's order comes in, I will send you guys out a copy of that. Or, and again, this is up to you. I'll put you in a chat room and you guys, if you can't resolve the case, so be it. Just take off and you're getting from me in the mail those things. If you're able to resolve it, come back to me and we'll put the terms on the record this time to avoid any additional failures to communicate. Your next day with me, August 16 at 10 o'clock. Put you guys in the chat room. And if you finish, if you settle your case today, come back to me. If you don't, and it's okay, then I'll look forward to the order in relationship to case evaluation. Put you guys in the chat room. Anything else, gentlemen?
No,
No,
thank you.
Your Honor, thank you.
Yes, sir. Let me get you guys in the chat room if I can make the technology work. You laugh. Not always the same. Doesn't always work for me.
Me either.
Okay, that seems to have you guys there. Okay, he's there. And Mr. Norman is there. Good. All right. August 16th. That brings us to. All right, come on. Mr. Neal, let's get started. We are on the record calling file 21-164-013, Michigan First Credit Union versus Toria Lewis. By a notice dated May 31st, 2022, this matter is set for hearing today, June 28th at 10 o'clock on the plaintiff's motion for summary disposition. It's now after 10:30. I have an appearance by plaintiff defendant has failed to appear. Sir, your appearance.
Good morning, Your Honor. Weston Neal on behalf of Michigan First, P number 80307.
Mr. Neal, did you receive an answer to your motion for summary
No.
disposition?
No, Your Honor, I did not, nor did I honestly expect one.
Indeed. Sir, your motion.
Yes, Your Honor. So as the court's well aware, this is our motion for summary disposition pursuant to C10. This motion is in regards to a vehicle deficiency from a 2011 Buick Regal that the defendant defaulted on. Per our motion, the vehicle was not able to be repossessed. Therefore, we sent out a skip claim to the credit union's insurer to pay out the loss value of the vehicle, which was applied to the outstanding balance. We are seeking to collect the remaining balance on the loan after that loss payout was made. The current balance is $6,176.05. The defendant has not provided any reasonable grounds for why this motion should not be granted and a judgment be entered against her for that balance, having not appeared today nor provided an answer as to why the judgment should not be entered. I do ask the court grant our motion.
Court has had an opportunity to review your pleadings here. Among the things supporting your motion for C10 is an affidavit by Cliff Murray, collections officer for Michigan First Credit Union, describing the balance at issue and how it was obtained. Michigan Court Rule 2.116 C10 provides that you may be entitled to summary disposition if there's no genuine issue as to any material fact in this matter. The court rule here is pretty specific, however. The court rule provides in 2.116 G4 that when a motion under sub C10 has been filed and supported, and made and supported as provided this rule, an adverse party may not rest upon the mere allegations or denials of his or her pleadings, but must by affidavit or otherwise provided in this rule, set forth specific facts showing that there is a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. In this case, we have a motion supported by affidavit and exhibits. We have no response from the defendant. Sir, your unopposed motion for summary disposition under MCR 2.116 C10 is granted. I look forward to your providing me with your judgment.
Thank you, Your Honor. I appreciate it very much. You have a good day.
Thank you, sir. Have a good day and let's be safe out there.
You do the same and have a happy 4th too.
And you too. Thanks for
Thank
coming.
you.
Bye-bye. We're off the record. Let's go see what's happening by breakout rooms. Oh, they're gone. Okay, so then we're going to close the docket for the morning. End.